The bloodletting of family court, when the system mistakes itself for the cure. For centuries, physicians bled sick patients and called it medicine. The patients became weaker, and the doctors, confident in their training, prescribed more bleeding. Modern medicine calls harm by treatment iatrogenesis. Family law has its own version. Families sometimes desperately need the protection of law. They need courts to restrain violence, fraud, coercion, concealment, parental alienation, and deliberate violations of orders. But needing legal protection is not the same as needing prolonged exposure to the family law system. Too often, the system mistakes itself for the cure when it is becoming part of the injury. 3 failures drive the damage. The first is a machine that manufactures conflict. A contested divorce often begins with a motion cataloging the other spouse's worst alleged conduct. One side strikes, the other retaliates, and the retaliation is then cited as proof that the first strike was necessary. Nearly every professional involved is also paid more when the case lasts longer. Lawyers, custody evaluators, private guardians ad litem, and therapists. That does not mean they are corrupt. It means the system contains incentives that do not reward early resolution. When a case becomes difficult, the reflex is to add another professional, another evaluation, another report, another hearing, and another delay, all under the respectable label of getting more information. But more information is useful only if it is reliable, actually affects the decision, and is worth its cost in money and time. The second failure is deciding major questions on thin evidence by design. Temporary orders determine who occupies the home and who sees the children, often through short proffer hearings without live testimony or cross-examination. Those orders should be treated as provisional guesses. Instead, the system creates a status quo and later treats that status quo as evidence. The child adjusts to the temporary arrangement. The arrangement becomes stability. Stability becomes the reason not to disturb the original guess. Delay is not neutral. It changes bargaining power, relationships, and outcomes. The third failure is referees who will not call fouls. When one party repeatedly violates orders or manipulates procedure, courts often relabel the conduct mutual high conflict and lecture both parties. A referee who refuses to call fouls is not neutral. The referee rewards the person willing to foul harder. The answer is not maximum process. It is minimal legal exposure consistent with real protection and real enforcement. Triage the case early. Decide what must be protected now, what must be decided now, and what conduct must stop now. Put temporary orders entered on proffer alone on a clock with a prompt evidentiary review before inertia becomes the outcome. Make misconduct expensive through fee awards, sanctions, compensatory parent time, and escalating consequences for repeated violations. Before appointing another professional, require the court to identify the specific question that professional will answer, the deadline, the cost, and the reviewable work product. If no one can state the purpose clearly, the appointment should not be made. Family law should not process families indefinitely. It should protect them, make reliable decisions, enforce those decisions, and then withdraw as quickly as justice permits. The physicians eventually stopped bleeding their patients because outcomes mattered more than confidence in tradition. Family law needs the same reckoning. Orders that mean something, deadlines that matter, referees with backbone, and then the discipline to put down the lancet and leave the patient alone.